in this talk I would like to introduce some ideas about management of personal data in the UA. I hope that you remain interested in this topic, because I will talk a lot about the current European framework, legal framework. Basically, it's a very interesting topic right now, because the regulations are changing. And also we, me and my research team, including people from here at the Imperial College and also in the University of Granada, in the Department of Law, we have been working in several projects, European project funded by the 7th Framework Program, and we have faced some practical issues on the management of this kind of data. So, well, I hope that I can translate the requirements that we have in these projects into a language that we can understand. Actually, my background is in computer science, so I had to do this work during the development of this project. And well, the problem of privacy is not new, and actually I like very much this citation. In 1890, Warren and Brandeis already talk about these numerous mechanical devices threaten to make good the prediction that what is whispered in the closet shall be proclaimed from the housetops. Harvard Law Review, blah, blah, blah. So, of course, the problem is not new at all. As I said, we faced, well, I was working in the development of data repositories in this two projects, in other national projects as well, but these are the two most important. The first one is Energy in Time, the second one is C-Police. The first one is about data processing for reducing energy consumption, for energy efficiency. Here, in principle, we didn't have any problem with data process regarding personal data, but at some point we started to detect that user occupancy and user behaviors in buildings are very important factors impacting data consumption. And also, we had data from 4 different demo sites in 3 different European countries. Data was processed in more than 8 different countries, so we have some problems sharing this data and establishing a common framework for this for this task. Both from the legal perspective, but also from IPR, from the IPR perspective, from property rights perspective. But the real problem, the real headache came with the e-Police project. This is a project on organized crime prevention. It is not about prosecution. It is not about finding evidences or detecting specific crimes. It is focused on the detection and monitoring of indicators of criminal activities and trends of these activities. We use data from open sources to detect general opinion and opinions and general trends. And in principle, we work with data from open sources. I will talk later about which kind of open sources we used in this project. These projects involve different European, national and regional law enforcement agencies. The project was classified, well, one of the classification levels of the European Union, so you won't find very much information about it in the internet, but the project is finished, so well, I can talk more or less freely about some part of the results. Well, anyway, the first question, or the initial question that we started we, the computer scientists, started asking to our colleagues in the law departments and the legal and ethical experts in the consortium of the project. In e-Police, basically was what are the limitations of using personal data. And if you have worked with lawyers, probably you know that the answer is, well, tell me more about what are you doing, and tell me more about you plan to do. So directly we got additional questions. The first one is, what is personal data? What can be considered personal data? And then we can start talking about the legal framework, the ethical limits, the technical requirements, the measures that must be implemented. Is anonymization enough? And finally, what should I do in my project, in my projects related to working with this data that may imply a risk to the privacy rights of the individuals? Well, I can advance that the answer to the last but one, to the anonymization question, is that it's not enough, and there is neither a final answer to the final question, which is, what should I do in my project? Actually, it depends on what you are doing in your project. Well, regarding the definition of personal data, well, currently, according to the European legislation, personal data is considered data that can lead to the univocal identification of individuals, and also additional information of interest attached to them. Well, as you can see, there is the definition is not very precise. Actually, the purpose is not being very precise, because this personal data umbrella can cover different kinds of data. Of course, it includes sensitive data. Sensitive data encompasses names, age, religious beliefs, and, well, everything that you can directly think when we talk about personal data. The situation with big data and machine learning technologies is even more difficult, because these two aspects, identification capability and interest, well, get more complicated to delimit. First, regarding the identification capability, it's widely known that in some cases we have data sets which do not include personal data, but further analysis or combination of them may reveal the identity of individuals. This was shown by Sweeney almost 20 years ago, regarding the combination of medical data sets with other data sets, and more recently, Yves de Mondeau, it's a colleague at Imperial College. Well, it will be starting on next January. He and other collaborators have shown that when data sets measure traceable human behavior, it is also possible to have a risk of privacy breach. And the other part concerning big data and current application is interest. Right now, we know that there are different companies that their primary interest is processing personal data. So then the object of interest is quite wide, and it is personal data itself. Well, basically, you know, Facebook is a company specialized in collecting personal data for different kind of purposes. Well, going to the small words, the current legal framework includes different directives and different decisions. We have a directive and a regulation in 2016. The regulation is about the general protection of personal data, and the directive focuses on the processing of personal data for prevention, investigation, or execution of criminal penalties. I will talk about the directive more than the regulation, because it gathers some ideas that are already covered in the regulation. As you can see, it's a very recent. These are very recent developments. Actually, they were published in May, I think. If I remember well, they were finally published in May. In the project, and in particular in the e-police project, we based our research on the pre-proposal for a directive that then led to Directive 600 on the protection for law enforcement purposes. Some concepts that are defined in this legal framework, well, we have the supervisory authorities, which are the public authorities in the member states, responsible for monitoring the application of the law. We have the figure of the data controller, which are the actors that process data and also determine the purpose of this processing. Basically, if we are working with data in the project and after the project, the law enforcement agencies using the product that we produce as a result of the project, they are data controllers. We have the privacy impact assessment, the PIA, which is a methodology and also the resulting document of the assessment of the impacts on privacy rights of a project, a policy, or well, any kind of initiative working with personal data, and also the explanation of the remedial actions that should be taken into account. This PIA document is usually developed by the data controller according to the provisions stated by the supervisory authority and also the other organization at the European level. And finally, privacy by design is a design paradigm that considers privacy from the very inception of the design of the system, and also promotes the implementation of the application of different technologies to implement the necessary safeguards. So all these concepts are included, well, they are scattered in different laws, but they are basically the most important when talking about a project that is working with personal data. In the directive for the use of data that may involve personal data for law enforcement purposes, we have different regulations, different requirements. Here they are collected very briefly. Of course, as you may guess, there are several details and several footnotes that should be done to this explanation. So it is important to have more legal experts when you are doing this kind of research, or when you are using this kind of results of research project. Some of these provisions are that data collection must be done for specified, explicit, and legitimate purpose. That is, if we are working with personal data, we need to be very specific about what we are going to do with this data. Other uses are allowed, and this is one of the main differences of the directive with respect to previous with other previous directive and decisions, are that other uses are allowed if they are not incompatible with the original purposes for which data were collected. Well, this notion of incompatible is quite wide, so in principle you won't find incompatible use in your typical projects. No collecting excessive data, no processing data excessively. That is, don't do and don't collect anything that you don't need for the purposes that you have already defined. The directive also states that no fully automated decision making should be made based on this data analysis. In particular, if we are working, as in the previous point, if we are aiming at profiling or tracking. Profiling is defined as the prediction or the estimation of behavior or of performance of individuals based on personal data, and tracking is tracking basically tracking people's activities and behavior in general. We have also the directive also compels to guarantee the right to access data by the subjects. That is, this is related to the right to forget, and these provisions made by the recently by the European Union. We need to provide the subjects the means for information, that is to inform which kind of data is being collected about them, rectification if data is not accurate, erasure or blocking if the processing is not according to the laws. Of course, we must implement security of data storage and transmission measures. The PIA is compulsory. This is also new with the directive, and the transfer to third countries are regulated by a different treaty, which is the Privacy Shield. The Privacy Shield is also quite recent. It was approved in August, I think, and it is an update of a previous treaty on the exchange of data with third countries. And this is not part of the directive because it is more focused on commercial data, but it is also important in the framework.
Sorry, just third countries are non-EU?
Yeah, in general, non-EU countries, yes. And basically, the Privacy Shield is focused on EU and the United States. Actually, it was updated as a result of a case of a complaint about the use of data by Facebook from the transmission of data by Facebook from Europe to the United States. And this was more or less the general framework. I would like to talk a little bit about the problems that we focused on this ePolice project, in which we wanted to build an environmental scanner, which was this software tool to identify and monitor the indicators and facilitators of the development of organized crime activities. The project had a very clear workflow. It included a first step on data collection and structuring. Then we applied data mining and machine learning techniques to identify patterns and anomalies on these trends. Then there was another step of data combination, data fusion, to build a threat model to evaluate general threats. And finally, there was the information, the results were provided to the analyst to proceed to the situation assessment step. In principle, in this project, we used open sources. That is, the project was specifically aimed at the processing of open sources. And by open sources, we mean statistical sources provided by statistical offices like Eurostat and local offices, and also data publicly available in the internet, like news from newspapers, posts in discussion boards, and initially we also considered the use of information from open social networks. That is, for example, Twitter, the open part of Twitter, or even the open part of Facebook. So I will explain later. At the end of the project, this information from social network was not used for different reasons, but initially the purpose was to consider them as part of the open data sources that were going to be processed by the environmental scanner. In the development of the project, we can also distinguish two parts with different implications on the use of data. The research task, which, as was explained in the previous task, well, there are less limitation to the use of data for research. But since we were working, the objective of the project was to build a system to be used by these law enforcement agencies, that is to go beyond research. The use of data was beyond research. Then we needed to make from the start of the project different provisions for the use in commercial, or so to speak, different purposes, different other than research. Well, this is a brief example on the use of the scanner. I'm putting this just to put in context the next slide. One of the use cases that we consider in the project is this one: the monitoring of human trafficking indicators. We collected information from newspapers and from reports from the quality agencies regarding investigations on fraud colleges. We found some correlation between fraud colleges and the presence of organized crime groups in some regions, but not in others. With all this information and with the help of analysts, we built threat models, including these trends or these events about frauds, other major events like changes in visa regulations, and also well-known conditions favoring human trafficking. For example, conditions or indicators favoring human trafficking, like low wages. And finally, well, the complete pipeline was able to monitor and the evolution of this organized crime indicators regarding monitoring of human trafficking, and also we were able to apply this to other regions. Initially, we focused on the West Yorkshire area, because one of the partners of the project was the West Yorkshire police here in the UK. Well, this is screenshot of the. I worked in the implementation of this, so this is the screenshot that I like, because we managed to put everything together and then to put the threads on the map. And in the project, we developed this PIA, this privacy impact assessment, and in collaboration with the technical partners of the projects, also with legal and ethical experts. There were also an external legal and ethical advisory board in the project, just to comply to all the requirements. And some of the conclusions that we obtained after the end of the project were this one. First, we had to identify that our project was not intended to process personal data, but it was possible in some cases to get personal data. For example, if we are processing news from newspapers, we can get people names or gender or other information. It's not the purpose of the project to use this information, but it might be processed. Of course, the intention was not to identify criminal acts and perpetrators. If this is the objective of your research, you need to make additional provisions, of course. The purpose is legitimate, of course. We use only open data sources. We are not using closed sources. Of course, we are not hacking into personal accounts. For this, you need a warrant. You need authorization for a court, a judge, or depending on the national laws. As I said before, we didn't use social networks, not even the open part of the social networks. And the explanation is that basically at the time of the development of this part of the project, the new directive was not finished. There was only the proposal for this directive, and it was not clear what can be done with this social network. Besides, the ethical experts recommended against the use of this, because the purpose when a user, when we put information in Twitter, in Facebook, basically we do this for personal or maybe professional purposes, but not to be tracked or to be monitored by the authorities. With the new directive, this in a progressive interpretation of the law, it could be done, but at this point, we were recommended against doing this for ethical reasons, not strictly for legal reasons. Besides, it was not possible to delimit in which situation the big data analytic process that we implemented could lead to privacy interference, and in small test data sets, we weren't able to prove that there was an increase of the accuracy regarding the macro indicators that we were focused. So finally, this network were not used. These are some of the technical measures that we implemented in the data repository. Essentially, we characterize all the information that we were collecting with a lot of metadata about provenance, about access level, and we also implemented mechanisms for the physical distribution of data. That is, for example, the information directly collected from the open sources, from the newspaper, was not stored in the same place that the results, the final results of the processing. The idea is that it was more difficult, is to make more difficult the connection between the results, in which we have summarized information, with the original sources, which may include more specific information about the individuals or the events that resulted in the final results. We implemented pseudo-anonymization of named entities. That is, we try to identify major events or people, or those that you can, basically those that you can find in the Wikipedia. They were identified, and we implemented pseudo-anonymization. Basically, we encoded names as numbers. But this was not enabled in the final version, but it was not very, it didn't mean privacy breach. A lot of security measures, but this is common for any project working with in security and also in other areas. Password-based access, IP filtering, access logging at different levels, also based on the previous metadata, and also, and finally, encrypted data transmission between the different components of the system. The system was fully distributed, so all the communication were encrypted. And we also enabled different measures to guarantee this data subject right that I mentioned before, like query of information to inform people of which kind of information is being or could be stored about them. Also modification and erasure of information. And a very important point is that within the project it was developed, designed and to be developed a comprehensive training program in order to train the final users of the system, of the scanner, the law enforcement agencies, to train them to use the system effectively, of course, to use the system in the way that it has been designed, but also to be aware of the legal and ethical implications that the misuse of the system could have. we developed at the end of the project a very powerful tool with a specific purpose, but it was not very difficult to use the system for other purposes. So this training program was focused or was intended to avoid this kind of problems. So just to finish, well, the conclusions is that the current framework is on development, so you may find changes in the next months, and for sure in the next years. The privacy impact assessment is a key resource, it's a key task in this regard, and well, the privacy by design paradigm establishes some good principle when we have to deal with personal data. The problem is that, well, there are only general principles and not a very specific methodology. What's ahead? Well, several questions in the near future. The first one is the translation of the directive into national laws. The directive sets the general regulation that then must be translated by the member states into national laws. So the question is how this is going to be translated, and in particular here in the UK. It's a very open, there's a very big question mark here, what is going to happen in this regard. I have talked before about transnational data processing and this Privacy Shield Treaty. There are also implications regarding merger legislation and data reuse. For example, the case that is now on the news about reuse of information collected by WhatsApp by Facebook after the merger. The merger legislation have also a lot of things to say here regarding data sharing, reuse, and all this stuff. And there is also an additional question, which is how we can, or how the authorities can enforce personal data protection laws. For example, there in this project we can implement all the measures to guarantee that the citizen can use these rights to access information, to erase information, and all this stuff. But if we have several organizations, several data controllers doing this kind of processing, it's going to be very difficult to go to each one of them and try to enforce these data protection laws. So this is not only a very interesting topic for working, for applied research, but also for theoretical research. When I was checking my notes for this presentation, I found this opinion of the European Data Protection Body, which is one of the organizations in Europe about this. They issued an opinion of enforcement of fundamental rights in the age of the big data, which, by the way, is very similar to the title of my presentation. And the title was before this opinion, so I think that we are in the right track for studying these topics. Well, of course, I have to acknowledge all the people that have worked on this, and my colleague Javier Valls from the Criminal Law Department of the University of Granada, which have made more than one contribution and correction to this work. Thank you very much.